Hello everyone, it is Law by Reese here back with another video, and in this video we're going through the full state's response to defendant's motion to disqualify lead prosecutors. Guys, we are continuing to follow the Young Thug Jeffrey Williams RICO trial with his legendary criminal defense attorney Brian Steele. Guys, my name is Reese Ringnauld. I'm a practicing attorney here in the great state of Texas. If you have been arrested in Nueces County, please give me a call. All right, give me a call. Okay, guys, with that being said, I've recently added in donation links to the channel. Guys, if you want to support this channel directly, you can find donation links to CashApp, Venmo, and then Bitcoin, Ethereum, and Doge in the description box below. Please make sure to like, comment, and subscribe, and let's get right into it. Okay, guys, so yesterday I uploaded a video on the first page because that's what Thugger Daily had. So Thugger Daily had the first page of the motion, and we've got the full motion here now. So I'm going to go ahead and read through it. And as I read through it, guys, I'm just going to give you a little bit of my commentary. Again, I am not a Georgia licensed attorney. I am a Texas licensed attorney, but a lot of the same sort of principles apply, but there are nuances, state by state. Okay, guys, this is the state's response to defendant's motion to disqualify lead prosecutors. Now, one of the things a lot of people, I've been surprised, are pretty interested in, how these motions are written, the law. So I will tell you a few of the things when you're looking at what's called a pleading paper here. So here at the top right, this tells you in what court it was filed, who filed it, the clerk that filed it, the date that it was filed, and then you can see the method of filing, which is pretty much always going to be e-filing. But sometimes you can physically take a motion up and hand it to the clerk and say, "I'd like to file this, please." Usually you've got to be like a pro se defendant to do that. But anyways, the top right is what's called the file stamp. And then the first section here is what's called the stylus. Technically, guys, the stylus is not a part of the pleading itself. But what the stylus shows you is the case number. It shows you the cause. For all of these criminal cases, it's going to be something like the state or the people or the Commonwealth. Here it's going to be State of Georgia v. Defendant. So here we have State of Georgia v. Jeffrey Williams et al. Defendants, case number 22 SC 183572, Judge Paige Reese Whitaker, and I think we're on like the third or fourth judge. One thing about state attorneys, district attorneys, especially federal prosecutors, these are state prosecutors, but federal prosecutors, one thing from a lawyering perspective you will find is that state attorneys, especially and really federal prosecutors especially, tend to have very polished and good looking pleadings. They just do. They have very professional. So one of the things when you're a lawyer that you notice is who's got the more professional and cleaned up sort of looking papers, and it's almost always the state or the federal government. Usually private attorneys don't always keep up with the rules of style and things like that. They don't always have the time to proofread as much as the state's attorneys do. So that's one thing you'll notice. Okay, guys, state's response to defendant's motion to disqualify lead prosecutors. The state of Georgia, by and through Fannie T. Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in opposition to defendant Jeffrey Williams, and Jeffrey Williams is Young Thug, motions to disqualify lead prosecutors, Chief Deputy District Attorney Adrienne Love. And then, guys, if y'all don't know what this is, that CDDA Love is telling you, hey, this is how we're going to refer to her throughout the motion. Okay? In the past, in sort of archaic legal writing, they'd write hereinafter referred to as, which would be, a little bit long. All right, but CDDA Love and Deputy District Attorney Simone Hylton, DDA, which means Deputy District Attorney, filed on July 10th, 2024, and on July 18th, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, let me comment on that for a section by saying, despite the extraordinary nature, no, there's really nothing extraordinary about that. This is a little bit of gamesmanship that the district attorney's office is using. There is nothing surprising. They might not agree with it. The state may not agree with the motion to disqualify its prosecutors, but that is not to say that the state is surprised. The state is not surprised. Of course, these criminal defense attorneys are doing everything to potentially get a mistrial and to get their clients out of jail. And ultimately, if it has to go to trial, the defense counsel is doing everything that they can to preserve error on appeal. So is it really that extraordinary? No, it's not that extraordinary. No, so that's just some gamesmanship there. Defendant cites no facts and no law that authorize this honorable court to disqualify either CDDA Love or DDA Hilton. That is language. So let me read that back. Despite the extraordinary nature of the request, it's not that extraordinary. That's just not true. Defendant cites no facts and no law, which is essentially saying that the defendant's motion to disqualify the lead prosecutors is baseless and frivolous, which, okay, fine, but it's not. I mean, you have to presume that motions by professional attorneys are brought in good faith. It even says right in the Texas Code of Criminal Procedure that motions are presumed to be brought in good faith. And there's a reason why the defendants are moving to disqualify the prosecutors in this lead case. It's because these prosecutors met with a sworn witness in an ex parte meeting that reeked of impropriety. All right. And now, in terms of Brian Steele being held in contempt, which is a new criminal charge to which he is entitled a notice and a hearing, and that's already gone up to the Georgia Supreme Court. No, this is not an extraordinary motion. It's not surprising to the state. And it's based in the fact that an ex parte meeting that reeked of impropriety was held. And so they say no basis in law, no basis in fact. Now, I'm not a Georgia attorney. I don't know Georgia law. But the basis in fact is an ex parte meeting with a sworn witness that reeks of impropriety. That is your basis in fact. And now Brian Steele is being held in, was charged with contempt of court, and he was arrested there in the courtroom. And so there's your basis in fact for the motion. And the two prosecutors are witnesses to the underlying event that led to Brian Steele being held in contempt, which is a criminal charge. In other words, these two prosecutors were in the room, as far as I understand it. They were in the room with Judge Ural Glanville. They were in the room talking to a sworn witness ex parte without defense counsel present. And so they're witnesses to the underlying act. That's what the basis in fact is. So that's just not true. There's no basis in fact. I'm not a Georgia attorney. I don't know about basis in Georgia law, but I do know basis in fact. Okay, accordingly, the state respectfully moves this honorable court to deny defendant's motion to disqualify the lead prosecutors. In support of this response in opposition to defendant's motions to disqualify, the state shows this honorable court the following. 1. Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to the defendant, the laws of Georgia and the facts of this case mandate this court's denial of defendant's motion to disqualify. Okay, so that is what we call a heading. Now that's a notice that it's a 1 inch by 1 inch, and then they do single space it down. I talked about, so whenever you get in with district attorneys or federal prosecutors, their pleading papers are generally going to be very clean and straight blue book form. So I do want to notice that. And then one thing that my legal writing professor always talked about, and you'll see it in these paragraphs, is that notice that their paragraphs always go out at least to the middle of the paragraph, which makes that's why the state is so good at what it does. The state is so good at bringing motions. These are state attorneys. Imagine now that these are federal prosecutors. Those pleading papers are going to be excellent looking. They're going to look intimidating. They're going to be well formatted, professionally formatted, and those paragraphs are going to go into the middle. The line's going to go to the middle of the paragraph. You're not going to have these tiny little words ending a paragraph. And they do that on purpose, guys. They do it to make it look more intimidating, to make it look more bulky. That's why the state is so good at what it does. Okay. Anyways, in support of his motions to disqualify the lead prosecutors, defendant asserts that, quote, Lawyer Love and Lawyer Hilton have made themselves critical witnesses in this case, end quote, when CDDA Love engaged in text messages with a witness, and when CDDA Love and DDA Hilton or Hilton participated in a hearing in chambers with a witness and his lawyer regarding contempt proceedings against a witness. Defendant cites no legal authority in support of his position. Defendant, however, bears the heavy burden of proving that disqualification of the lead prosecutors in this case is warranted. See Lewis v. State, Volume 312, Georgia Appellate 275, page 283, 2011. And then, guys, I know a lot of you are not attorneys watching this. I'm just going to tell you how you read this. So this is a physical book. It's a reporter. Okay, it's the Georgia Appellate Reporter. So it's Volume 312 of the Georgia Appellate Recorder. And that case starts, Lewis v. State starts at page 275. And the quote that they're looking at, their case law that they're looking at, begins on page 283. That's called a pinpoint citation. And the case is a 2011 case. Okay. Instructing, so this is a quote from Lewis v. State on page 283. Instructing that it, quote, it is the burden of the party seeking to disqualify counsel to prove ellipses. Now, there should be, hey, I don't want to say anything about anything, but they missed their, that should have brackets. The extraordinary remedy of disqualification is warranted. So, what they're saying is they're citing a case here from the Georgia Criminal Appellate Court, which is binding precedent, meaning that the lower court or the trial court has to follow the case law of the appellate court or the Georgia Supreme Court. So here, for example, in Texas, we have the trial court, and then we have our courts of appeal, and then we have two Supreme Courts. We have the Texas Supreme Court, which hears civil cases, and then we have the Texas Court of Criminal Appeals. And the Court of Criminal Appeals is our Supreme Court for criminal cases. So in Texas, we have two separate Supreme Courts, one that only hears civil cases and one that only hears criminal appeals. Okay, so defendant does not even attempt to meet this burden. Instead, he rests his pleadings on legally and factually unsupported assertions. Again, there is a fact there. Now, they're trying to paint that ex parte meeting as an ex parte hearing, which, look, it just reeks of impropriety, why the defense was not present at that meeting. Okay, Cap A, the hearing in chambers was proper. Defendant asserts, so they're going to go into their argument of why the hearing that Brian Steele is complaining about was proper. Okay, because that's the underlying thing that Brian Steele is complaining about, that Jeffry Williams, his client, through him, is complaining about, is the meeting in chambers with the judge. Defendant asserts without support that CDDA Love and DDA Hilton are disqualified as prosecutors in this case because they attended a hearing in chambers that he believes himself entitled to have attended. Not great English. I mean, this is I'm going to be honest, I expect a little bit better from the DA's office. That's not a wonderful sentence. Defendant argues that the lead prosecutors in attendance at the hearing are disqualified under Georgia Rule of Professional Conduct 3.7 sub A, 3.7a, from further prosecuting the case because defendant now, I'm just saying, for a district attorney's office, some things could be different here. That was a very run-on sentence, and now we have a comma here before because. I mean the formatting is good. The formatting is good, but I'm not sure why there could have been a little bit more proofreading done here. Because defendant now needs to examine them about the hearing and what took place. And then defendant's argument is not grounded in law. So that's a good sort of punchy sentence. I like that. The hearing in chambers was about an ongoing contempt proceeding against a witness who, upon motion of the state, had been compelled to testify but refused to do so. And then we have a citation to the transcript of the ex parte hearing in chambers. The hearing was proper. And then we have C. King v. State, 273 Georgia, 258, 264 to 265. Now notice, I told y'all in my last video that Brian Steele did not use his in dash, but the state The state uses its in dash. Just saying, that's the medium size. If y'all don't know what that's called it's the medium size dash. The in dash 264 through 265. Ruling where King had complained, quote, that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify in King's trial and confirming the use and derivative use immunity that would apply to that compelled testimony. The hearing appears not to have been a part of the proceedings against King. The Georgia Supreme Court pointedly recognized in King 273, Georgia. Forgot a period there. There should have been a little bit more proofreading done on this, okay? I mean, just saying. There's no period there. Georgia 265 through 264 to 265, under circumstances closely resembling those here that, and we forgot our colon. Guys, I'm sorry. I mean, my autism requires there to be proper formatting here, and I beat myself up whenever I make typos. And we're forgetting a colon, state of Georgia. Forgetting a colon here. Okay, starting. While King might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order compelling the witness to testify in King's trial, or that would suggest that King's rights were the subject matter under consideration. And then C. Williams v. State, Volume 234, Georgia Appellate 191, 193 to 194. It's a 1998 case. On the contrary, the trial court was obliged to consider whether the testimony was, quote, necessary to the public interest, end quote, a matter which King had no standing to address. And then we see OCGA, which I think is Official Code of Georgia Appellate, annotated, Section 24-9-28, sub A. Any alleged bias on the witness's part was the proper subject of cross-examination, not grounds for denying the state's request for the order. See Mosher v. State, and that's a 1995 case, holding that the credibility of a witness ordered to testify under OCGA Section 24-9-28 is a jury question. Emphasis added. That period should have gone outside that paren. Likewise, in Allen v. State, 336 Georgia Appellate 80 at page 81, a 2016 case, the Georgia Court of Appeals cited King in support of its holding that a defendant had no standing to contest the grant of use immunity to a witness. Okay, so y'all probably don't. If you're not an attorney, you might not know what use and derivative use immunity are. But basically, Kenneth Copeland, who is a key witness he's the state's key witness in the RICO trial against Young Thug and Yak Gotti and a number of other co-defendants. Your Fifth Amendment right against self-incrimination goes out the door when the state offers you immunity. And so you can be compelled to testify when there's no jeopardy. The reason why, and this is the law on that. The reason why you have your Fifth Amendment privilege against testifying against yourself is because it goes in with jeopardy. The state is putting your life, liberty, and property in jeopardy. And so you have the right, while you are in jeopardy, not to testify against yourself. But immunity means we're not going to prosecute you, and we cannot prosecute you for this crime. We need your testimony. And so, for example, with Kenneth Copeland, he might be the only source of testimony for a key element of the RICO case. Okay, so they need to show that there was an organized conspiracy to commit crime. Okay, so... And in order to do that, they need the testimony from Kenneth Copeland that one of them shot another, I forgot his name. I think his name was Nut. His name was Nut, but one of them shot Nut. And so the state needs Kenneth Copeland's testimony to prove up that one of the other co-defendants shot Nut. And Kenneth Copeland has been offered immunity for his testimony in this case. And so because of that, he no longer can assert his Fifth Amendment right against self-incrimination. That's the idea behind that. So use and derivative use immunity are, you are immune from whatever you tell us. You are immune from this case. And then derivative use immunity is whatever we might find from your testimony. So let's say that you start telling a story about the crime that was committed, the crime scene, and then the police go out and find a body part or something like that. That evidence cannot be used against the immune party because it was derived from immune testimony. So that's derivative use immunity. So there you go. Sometimes when the state is not confident that it can convict someone, it will offer a key witness immunity and then derivative use immunity on top of that, so that witness cannot be prosecuted for that crime. Okay, so that's use and derivative use immunity. And for all you law students out there, you're going to learn that in con law. Okay. Under both King and Allen, the June 10th, 2024 in-chambers hearing was proper, semicolon. I don't know why there's a semicolon there. And defendant had no standing to contest the hearing. So standing, what is standing? Standing is you have to be the right person to sue. You have to be the injured party. So the state here is making the argument that there's a similar case here where there was an ex parte meeting over immunity and it really had nothing to do with the underlying case, and therefore the underlying accused did not have standing to sue. That's standing. Standing means you have to be the injured party to sue. Had no standing to contest the grant of use immunity to a witness. Under both King and Allen, the June 10th, 2024 in-chambers hearing was proper, and defendant had no standing to contest the hearing or to participate in it. Ending a sentence with a preposition. It's just terrible. Surely defendant does not expect that a proper hearing, which he had no standing to contest or to participate in, now somehow provides the defendant the right to disqualification of the lead prosecutors who took part in the hearing. Such a position makes no sense. Now, yes, when that's what we call a straw man argument. So if you start with the predicate, like the state here is that the ex parte meeting was proper under King and Allen, if you start with that predicate, then obviously young thug Jeffry Williams really has no argument. But if you start with the predicate that the hearing was not proper and that it reeked of bias, and I personally just think that it violated the defendant's right to be present. I think it was not proper, although again I can see the state's argument here. If you start with the predicate that meeting with a sworn witness without defense counsel present, if you start with the predicate that was improper, then it's not an absurd argument. So this sort of language, it makes no sense. It's absurd. It's ridiculous. I just think it's a little bit over the top. Like, you have to presume that your opponent on the other side is intelligent and is making a good faith argument, and I don't know. I just think it's a little bit unprofessional to say it makes no sense. No, it does make sense. There is logic in it. And of course, Jeffry Williams, young thug, he and his attorney want to have as many issues to throw up on appeal as possible, sort of a kitchen sink approach to try, even if there is a conviction, they want to try and overturn that conviction. And so, throwing up this motion to disqualify the lead prosecutors gives you more ammunition on appeal, and the state knows that. Cap B, disqualification of the prosecutors would constitute an abuse of this honorable court's discretion, where other sources of evidence about what happened at the hearing are available to defendant and obviate any, quote, need of defendant for either prosecutor's testimony. Okay, so now you can see that they made an argument here under some existing Georgia state law. Under some existing Georgia state law, the state made an argument that the meeting in chambers was in fact proper. And so now we go into the alternative argument. And when you're an attorney, what you do is you've got a result that you want. You're going to argue it this way, and then even in the alternative, if that's, hey, you're not buying that argument, how about this argument? And how about maybe number 3? And how about in the alternative number 4? Give me what I want, judge, please. So anyways, so here we have an in the alternative argument. Even if the hearing had not been proper, an even bigger hurdle barring disqualification of the prosecutors is the availability to defendant of other sources of evidence of what happened during the hearing. Now, this is what we call the best evidence rule, or it goes into that a little bit. I disagree with this point. I mean, the prosecutors are witnesses to an improper meeting, and their testimony is the best evidence, in my opinion, even if there are alternate sources of evidence present. As I stated in my last video, I am of the opinion that this motion to disqualify these 2 prosecutors is likely to be denied. But I think it should be granted. But I think it's going to be denied. If I had to be honest with you, I think it's going to be denied. But it's a good thing that Brian Steele and Jeffry Williams filed the motion, because then they have some more ammunition on appeal. So I think it makes sense that at least they filed the motion. Okay, here we go. I'm going to take a quick pause here. Guys, you're going to see a little cut in the video, and we'll be back. All right, guys, welcome back. With some exceptions, Rule 3.7a of the Rules of Professional Conduct of the State Bar of Georgia provides that, quote, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. However, the party moving for disqualification of a lawyer under Rule 3.7 has the burden of showing that the lawyer is likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact and that there is no other evidence available to prove those facts. And then we see Clough v. Richello. Defendant cannot meet that burden. So the state here is arguing that, all right, even if that ex parte hearing was improper, and y'all know my opinion on that, I think it was, in fact, very improper. But even if that ex parte meeting was improper, because it doesn't go to the underlying dispute, meaning the RICO charges, that it's harmless error, basically. There you go. The hearing in chambers was taken down by the court reporter and transcribed. All parties now have the transcript of the hearing in chambers. The transcript clearly identifies those who were present, and that includes sheriff deputies, investigators from the district attorney's office, the witness currently on the stand, and the witness's attorney. Indeed, defendant will get to cross-examine the witness at issue himself. Quote, the practice of trial attorneys testifying is not approved by the courts except where made necessary by the circumstances of the case. And this is Timberlake v. State. That's a 1980 case. The advocate as a witness poses innumerable threats to the integrity and reliability of the judicial process. And we have a Castell v. Kemp. That's a Georgia case out of 1985. And then in bold here, so they really want to emphasize this one, courts have properly refused to permit a prosecutor to be called as a defense witness unless there is a compelling need. And then here we see an 11th Circuit case. Trial circuits are generally held to have discretion on whether to allow a party to call opposing counsel as a witness, on the view that attempting to call opposing counsel to establish some fact that can be readily proved in a different manner should be discouraged. And then Louisiana v. Tusno, that's a Louisiana case. Now, I don't know why they're citing to a Louisiana case in Georgia, but they are. So, guys, in case you don't realize, all of the 50 states in the United States are separate and independent jurisdictions. And so when you are citing a Louisiana case in Georgia, it's like, okay, they said that in Louisiana, but that's not what they said in Georgia. So it's not the best practice as an attorney to cite to other jurisdictions. But of course, they're trying to bring on as much case law as possible. I do see that here in Texas, where sometimes you'll see cases in other jurisdictions get cited because maybe there's not just the case law that you want out of Texas. But the judge is going to look at that, and that's not terribly persuasive. So when at all possible, you want to cite to case law from your jurisdiction. There is no compelling need for the lead prosecutors to testify, especially given that there are ample other sources of information to establish what occurred at the hearing in chambers. So the prosecutor's argument here is, first, the meeting was proper, and then you can see in the alternative, even if the meeting wasn't proper, that we should not be called as witnesses because, we've given out the transcript now. Now you can see what happened in chambers, so you don't need to call us to testify about what happened in chambers because you have the transcript. And if I were the judge, I would have a difficult time disqualifying these prosecutors, but I understand why Brian Steele moved for it, and it gives him something on appeal as well. C, disqualification of Prosecutor Love based on the exchange of text messages with a witness also would constitute an abuse of this honorable court's discretion where other sources of evidence about the text messages are available to defendant and obviate. So guys, if y'all are not familiar with what obviate means, it means render useless or render void. Obviate gets rid of any need by defendant of CDDA Love's testimony. With ample sources of evidence about the text messages being available to defendant, most notably the witness himself, who's Kenneth Copeland, Little Woody, whom defendant already has examined at trial. And then, guys, your autism here is going to notice that that's an N dash. That should be an M dash. So there are 3 different dashes. There's the little tiny hyphen, okay, like when you hyphenate a name. The N dash, meaning to or through. You use that between like 2 dates. And then you have the M dash. And the M dash is what they should have used here to basically separate 2 sentences, kind of like a semicolon. I love using M dashes, but they used the wrong dash here, okay? And I notice. Defendant asserts that the text messages also require his examination of CDDA Love. And then we have footnote 1 here. Defendant's motion contains no reference to his examination at trial of the witness or to the text messages introduced at trial through the witness. Okay. The law contradicts defendant's assertion. And then we see example here, Schaff v. State, 2010 Georgia appellate case, noting that, quote, speculation as to the content of an opposing counsel's testimony could not support a disqualification order. You see, and then you put the quote outside the paren. Guys, what's going on here at the district attorney's office? I mean, come on now. It's quote and then paren. All right, the Georgia Court of Appeals held in Schaff v. State that the trial court abused its discretion when it disqualified trial counsel on the basis that the trial counsel's testimony was necessary where the victim made a statement in his presence. Oh, guys, so let me tell you what happened here. Now, this is just a little sidebar, this is just my autismo speaking, but this response got passed around at the district attorney's office there, and one of them was like redlining it, and they forgot this part right there. That's why that's in red, because that was supposed to be redacted out. So this motion got filed without a sufficient amount of proofreading. Made a statement in his presence, but the statement had also been overheard by both the victim's mother and by trial counsel's assistant, who could testify to the circumstances surrounding the child's statement. Although the Schaff court agreed with the trial court's concern that the trial counsel's testimony, quote, would be relevant to the jury for determining the weight and credibility to assign the child's videotaped recantation and possibly the preferred method, the Schaff court ultimately concluded that trial counsel's testimony. So, guys, in case you don't know this, the reason why this is in square brackets is because the case, it's just to make it grammatically correct. That means it wasn't actually in the opinion. Trial counsel's testimony was not necessary to prove any fact related to the video or the circumstances surrounding the video. In Clough v. Riccello, this court explained that such speculation as to the content of an opposing counsel's testimony could not support a disqualification order. Otherwise, any party could successfully move to disqualify an opposing attorney by simply averring. Averring is an old-fashioned way of saying asserting. Averring that the opposing attorney might possess information that is damaging to the attorney's attorney's client's case, that should have a comma there, and, comma, therefore, that the attorney is likely to be a necessary witness in the moving party's case. To approve of such a tactic would be opening the door to blatant misuse of a rule that already has great potential for abuse. And so you can see here that the DA's office put this in italics and then said emphasis added. And this time they got it right. Defendant proffers meaning like offering. Defendant proffers no information he seeks to gain from CDDA love that he cannot, quote, quite readily get, has already gotten. See, that should really go in a footnote or something. That's not good writing there. From another source. Disqualification of the lead prosecutor under these circumstances would constitute an abuse of this honorable court's discretion. And then we have Cap D. Defendant's reference to the former trial judge has no bearing on defendant's motion to disqualify. Although it is not necessary for the present motion, comma, Williams asserts that he wants to call as a witness the chief judge who until recently presided over the trial. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors are not necessary witnesses. Moreover, while at no point did the chief judge comment on the evidence before this jury, it appears defendant's primary purpose in calling the chief judge would be to ask him to do just that. Although defendant has not requested permission to do that yet, the state submits the court should deny such a request when and if it is made. And then we have Roman 2. So basically, the state is expecting or anticipating that defendant Williams, meaning Brian Steele, his attorney, but that the defendants are going to try and call Chief Judge Glanville to the prior judge to come and testify as a witness in the current trial. And even though they haven't done that yet, the state is anticipating that that's what they're going to do. And the reason why the state anticipates that is because, of course, the defendants are trying to get this case out on a mistrial. And they're trying to throw as much in the kitchen sink for appeal were there a conviction, which is what a good attorney should do. A good criminal defense attorney should use all of the angles to get his client out of jail, get him on bond, and then preserve as much potential error for appeal to overturn a conviction as possible. And that's what a competent criminal defense attorney is going to do. Defendant does not allege, nor does there exist evidence in this case. So really this should be a neither nor. It should read as follows. So not or nor are not technically good English. It's defendant neither alleges nor does there exist. So that's just better English. Defendant does not allege, nor does there exist evidence in this case, suggesting that either prosecutor in this case should be disqualified under the two only generally recognized grounds for disqualification of a prosecutor in Georgia. 1, an actual conflict of interest exists, or 2, a prosecutor has engaged in forensic misconduct. In McGlynn v. State, and this is a 2017 Georgia appellate case, the Georgia Court of Appeals recognized that a trial court considering a defendant's motion to disqualify an elected district attorney or her staff based on alleged misconduct must hold, and then that's a typo right there. Oh boy. Hold those who allege such misconduct to a high standard of proof. Even assuming for the sake of argument that the allegations set forth in defendant's motion were true, those allegations fail to meet the high standard required to disqualify two lead prosecutors from an ongoing and well-advanced criminal case in the middle of trial. The extraordinary, which, guys, the well-advanced, that kind of cuts both ways. The extraordinary relief defendant Williams seeks is simply unwarranted, and his motion should be denied without any further proceedings. And then we have footnote number 2 here. Footnote number 2 here reads, additionally, the court should deny the defendant's motion as not being sufficiently particularized in violation of the court's standing scheduling order for criminal cases in Judge Whitaker's division. His motion does not specify with particularity any evidence that supports his desired relief, At best, the defendant has merely cobbled together a broad and barely defined class of allegations to support his theory, but he has utterly failed to explain how such allegations would necessitate or even authorize disqualification. Utterly failed? I mean, is that really necessary to say? But he has utterly versus he has failed? Utterly failed? Okay. Number 3, conclusion. So Roman 3, conclusion. Oh, you see, he didn't center that one, huh? Okay. 3, conclusion. For the reasons stated above, it would be an egregious abuse of this honorable court's discretion to disqualify CDDA Love and DDA Hilton based solely on the de minimis assertions. So if y'all don't know what de minimis means, it means bare bones or bare, yeah, minimal. Based on the de minimis assertions advanced in defendant's motion, especially where there is no evidence of any ground authorizing either prosecutor's disqualification. This court should not abuse its discretion by disqualifying the prosecutors, especially where the June... Oh, Fanny, we missed a space here. So we missed a space, and Roman 3 conclusion is not centered like the other headings are. And need I mention that y'all forgot the word, the spell check on word there, and that's why this is in red. So yikes, Fanny. We need to do some proofreading here at the DA's office. I'm sorry. It's just, guys, you just have to know that's exactly how I am. Wow. Okay. This court should not abuse its discretion by disqualifying the prosecutors, especially where the June 10, no space, 2024 hearing, about which defendants incessantly complains, and then bold, underlined, and look, even that comma there is bold, was all caps proper. Fanny's screaming here. I mean, she's screaming. Yes, you might incessantly complain if you feel that your client's rights to have counsel present in front of a sworn witness and that there's an improper ex parte hearing, even if it's not quite improper, but it reeks of improper conduct, you might incessantly complain about your clients. That's not a good look, Fannie Willis. I mean, yes. Why? Because, of course, his client is going... I mean, yes, you're going to complain about your client's rights being violated. Oh, man, defendants... about which defendants incessantly complain. By the way, defendants complain. You forgot that. See, that's a singular, and that should be complaint. So it should read, about which defendants incessantly complain. It should not be complains, that's singular, was proper, and where there are available to defendant other sources of the information about which he claims to need to examine CDDA Love and DDA Hilton at trial. So, guys, when Fanny here got to the end of this motion, she was upset, and so she decided, all right, we're gonna underline it, we're gonna bold it, we're gonna cap it, and we're gonna say proper, all capital letters, bolded and underlined, because as you know, guys, it's more persuasive to the judge if you are screaming than if you are not screaming. So, anyways, defendants' efforts, and then this should be defendants as in plural, defendants' efforts to forestall the conclusion of the longest trial in Georgia history. Now, whose fault is that, Fanny? I don't know if that's always the defendant's fault for there to be not quite the most speedy, a slow trial. That's not all on the defendants. It's also on the state. And then footnote number 3. Unbelievable. I mean, yeah, you're right to a speedy trial. By seeking to disqualify the lead prosecutor should be immediately stopped. Immediately stopped. This honorable court should deny defendants' motions to disqualify the lead prosecutors in this case on the pleadings alone. And then you see here, I think Fanny might have just written the conclusion. So if I had to take a wild guess here, obviously I think multiple people wrote this. This heading should not be on page 3. That's hanging out there. That should not be on page 3. That's something. And then, that's just a big oversight there that you forgot your word editing function there. And by the way, this, you see Roman I here and cap A. Yeah, A should be further indented, so these should not be on the same level. So A should be indented 1, 2, 3, 4, 5 over. And then I think when Fannie just wrote the conclusion, Fannie decided incessantly complains was proper, and bolding, underlining, yes, the defense counsel is complaining about what he views as an improper ex parte hearing, and he's trying to defend his client zealously. I mean, Fannie, that's what a defense attorney is supposed to do. It is your job. You are employed to defend your client, to number one, defend your client, get him out of jail, to acquit the client, or to get an acquittal for the client, or to get the client the best plea bargain that you can possible. And then number four, all these various avenues of trying to protect your client's rights and procedure. Yes, he's complaining because that's his job to complain. It is, in fact, his job, what he's employed to do. All right. I'm sure he doesn't personally want to be there all day, every day, but that's his job. I don't like that at all. I don't. Incessantly complains. Yeah, incessantly complains for his client, for whom he is supposed to advocate zealously. I don't like that at all. And then we see here, respectfully submitted this 26th day of July, 2024. And then, okay, Fannie T. Willis. All right, then we have, guys, the certificate of service. And then it was emailed over to Brian Steele and Keith Adams. So that's your certificate of service. Guys, my opinions on this I have described before, but I will describe again, which is I do not foresee the court, if that case law which was cited here in this motion is the binding precedent in Georgia, then I am of the opinion that the two lead prosecutors are not going to be disqualified. However, I think it is remarkably unprofessional and remarkably questionable. I mean, I'm remarking upon it. That's why I believe it is remarkable, because I am remarking on it. Incessantly complains was proper, and bolded, underlined, and then bolded, capped, all underlined. I mean, you're screaming in your motion. I think that is a little bit unprofessional, or actually quite a lot of bit unprofessional. And there's no need to do that in your motion. And yes, I think that what this response shows is the frustration on the part of Fannie Willis and the Fulton County District Attorney's Office, because they want their convictions and they're having a difficult time getting their convictions. And frankly, I think that the momentum as of right now is on the defense side. I think there's a decent chance, 40, 50, 60% chance. I think there is a decent chance that this case is going to go to a mistrial before it even gets to a jury. Now, the worst thing for the district attorney's office here in terms of Fannie's reputation is Young Thug and this RICO case is thrown out on a mistrial with jeopardy attaching, so they can't even refile it. So imagine all of the money, the time, the expense, and the labor that was put forward in prosecuting this case, only for it to be declared a mistrial with jeopardy attaching. All that money just wasted, all that time wasted, all the labor wasted. But honestly, whose fault is that? That's the district attorney's office fault, in my opinion. First off, for bringing a case for which maybe they didn't have sufficient witnesses or sufficient evidence. But number two, for having that ex parte meeting that it should have struck someone, that even if it was not by the literal terms of the case law improper, but it should have struck someone that it at least appeared improper. It should have struck someone in that room that it at least appeared improper. And this, I don't like attacking the defense attorneys who are doing their jobs that they are paid money to do. They are paid to complain and to preserve any potential error for appeal. That's their jobs. They are incessantly complaining because it's your job to defend your client. And I don't like that aspect of this whatsoever. I just think it's unprofessional, and I think that screaming in your motion is less than professional. And you know why Brian Steele, Jeffry Williams filed the motion, because they're trying to preserve as much air for appeal as possible. And I just that's his job. That's his job. That's what he's just like. That's actually what he has to do. So I don't like that at all. But all right, guys. Well, I've gone ahead and read out the full motion here of the state's response to defendant's motion to disqualify lead prosecutors. And as I told you before, I think that the motion will not be granted. But I have a number of issues with this that I've outlined before. But guys, these are all just my opinions. I am not a Georgia licensed attorney, so please take this with a grain of salt. I'm only licensed here in the great state of Texas. Guys, if you enjoyed this content and you want to support me in a big way, there are donation links to CashApp, Venmo, and then Bitcoin, Ethereum, Doge. There are donation links in the description box below. And then please make sure to smash that like button and ring the little bell notification, guys. This is Law by Reese. I'm an attorney here in the great state of Texas. And guys, if you are in need of some legal aid here in Texas, I'm in South Texas, feel free to use the email contact link, and you can get in contact with me. But all right, guys. And by the way, if you are outside of this jurisdiction, I cannot provide you legal advice outside of Texas. Okay. Bye-bye.